transparency, and accountability. My name is Joel. I'm Joel Basoga. Today we have distinguished panelists who will be leading this conversation today. We have the Acting Director for e-Government from NITA, the National Information Technology Authority. We'll have the Director of the Personal Data Protection Office, who will also comment on the topic. We'll have the Director of Regulations and Legal Affairs from NITA again, and also we intend to have SSP Jimmy Haguma from the Uganda Police, who's supposed to join us online. I hope that a link was availed to him to be able to facilitate this discussion. We shall also have Mr. Mustafa Barnabas Mugisa from Summit Consulting, who will shed light from his private experience as a cybersecurity consultant from Summit Consulting to take this conversation forward. I'm very excited. I see that now we have quorum. We have quorum. We have online quorum. I understand there are a number of participants online, and I have been allowed and approved to proceed to introduce our panelists for today on this very important topic of safeguarding privacy, a focus on data security, cybersecurity, risks, transparency, and accountability. We'll be starting in 1 minute now. Like I said, we had 10 minutes to accommodate the lunch break for those that are in our physical audience. I understand there's been high demand for this panel, and I associate with that enthusiasm because, like I said, I was here at 6:45 a.m. ready to moderate, but my itching hands were held at ransom by the keynote speaker, the Minister for Justice, and the relevant protocol that we observed in the morning. And now I'm excited to be able to engage in this conversation. I will just confirm with our technical persons that the representative of the police will attend virtually, and then we can perhaps start the conversation. Thank you very much. In a minute or so, we will start this conversation on cybersecurity, and I'm excited to lead this conversation. Okay, thank you very much. I've received full clearance to start our discussion. My name is Joel Basoga, your moderator for this panel discussion on safeguarding privacy. I focus on data security, cybersecurity, risks, transparency, and accountability. I work with H&G Advocates, where I head the technology practice, and I'm really excited to be here. In a minute, I'm going to introduce our panelists, but today's discussion is ever more important, especially with the digitization of government services here in Uganda. Most of you now, we had the Registrar General for URSB here with us. They have digitized registration, Any correspondence you're doing with immigration has also been digitized. We have an online case filing and management system through ICMIS. And today's panel discussion will espouse some of those points. Some of our panelists have been the people engineering the e-governance system that has been rolled out here in Uganda. But also we have the regulator, the Personal Data Protection Office, that is going to shed light on the conversations that we will have. At this moment, I'm going to invite our panelists up. I will start by inviting, I will read out the name, read out the brief bio, and then I will invite the panelists to take their seats. At this moment, I would like to invite Ms. Julian Rejou, I hope I pronounced that well, the Acting Director of E-Government at NITA. Ms. Julian Rejou has over 20 years working experience working in the ICT sector, both in private and public sector. She's working with NITA Uganda as the Acting Director of E-Government Services, providing an oversight role in e-government implementations, such as ICMIS, and also she is an ICT law on the ICT Law Reform Committee and a board member of the ICT Committee for the National Drug Authority. She has supported various projects such as ICMIS, in the judiciary, the immigration for the Directorate of Immigration in the Ministry of Internal Affairs, and other e-government systems that you've interacted with. She's passionate about digital transformation and promotion of ICT infusion in the public sector for better service delivery. She holds an MSc, a Master of Science in ICT, a Master of Business Administration, and several certifications in project management. And she's also a certified software engineer and database engineer, among the others. Please join with me as we welcome Ms. Julian Rejou to take up her seat at the table. I think we can do a better hand clap, especially for the person who has designed ICMIS, designed immigration. All the excellent things that you can associate with that system are here today. And those other ones also we would like to engage her on. Second, we'll have one of the most powerful people in our country in the data sector. A lot of decisions have been issued by this office against some of our leading corporations in the world, names like Google, Cheaper Technologies, and some of you might have a question or two for him. I'd like to introduce to you Mr. Baker Birikuja, who's the director, the acting director for the Personal Data Protection Office of Uganda. Mr. Birikuja is a legal and regulatory and compliance leader with over a decade of experience, including more than 5 years at senior management level spanning data protection, IT regulation, and cybersecurity. He is the acting Personal Data Protection Director for Uganda's Personal Data Protection Office, where he leads the nationwide strategy and enforcement and coordination of the Data Protection and Privacy Act. His earlier career at NITA, I see that there are a lot of old boys and old girls at NITA. I think this is a small reunion club for NITA, which I think is justified, especially since it's a digital transformation festival. So I understand that he spent his earlier career at NITA serving as manager legal services, legal officer for regulation and compliance. In these roles, he provided regulatory oversight of the national certification of companies and individuals providing IT products to the government of Uganda. He also advised on the legal and cybersecurity implications of cloud services and government-wide IT systems. Baker represents Uganda in high-level policy regulatory forums, including the Global Privacy Assembly, the Africa-Asia Policymakers Network, the African Union Data Governance Committee, the East African Community Data Protection Harmonization Technical Working Group, and he has co-authored with the Uganda chapter of Walter's Kluwer Privacy Technology 2021, and has also contributed to the AI Policy Playbook for Africa and Asia. He holds dual International Association for Privacy Professionals certifications, including CIPP, Certified Information Privacy Manager, and is also a fellow of the same organization. I don't know how higher you can go in terms of privacy certifications, but I think our director has had all the humanly conceivable qualifications. I'm also proud to say that he's a graduate of Uganda Christian University, where I'm an alma mater and also a lecturer. So I'm excited to see that you are here, and also he holds a postgraduate diploma from the Law Development Center. Please join with me as we welcome the Director for the Personal Data Protection Office, Mr. Baker Birikuja. You should be clapping a little bit more. This gentleman has a lot of authority conferred to him by statute, obviously. So our next panelist is also, again, like I said, NITA Uganda has a lot of people represented here, and I think that's a logical inference because they're leading the key conversations on technology here. I'm inviting Ms. Caroline Akelo Mugisha, who's the Director Regulations and Legal Services at NITA Uganda. She holds 10 years experience in IT and regulatory field and has been instrumental in promoting the awareness and compliance with IT laws in the public and private sector. As Director Regulation and Legal Government Services at NITA, she supports the Board of Directors, the management and staff on corporate governance and legal advisory matters, and she also heads the certification arm of NITA Uganda that registers and regulates IT product providers. Prior to her role at NITA, she headed the compliance function at Stanbic Bank Uganda Limited, protecting the bank from regulatory sanctions and pioneered key compliance forums. She also held other managerial positions spanning over 13 years of experience. She holds a master's degree in business administration, obtained from the Eastern and Southern African Management Institute, ESAMI, and she also holds a Bachelor of Laws from the University of Dar es Salaam, Tanzania, and a postgraduate diploma in legal practice from LDC. And she has various certificates in leadership and ICT management. Please join with me in a round of applause as we welcome Ms. Caroline Akelo Mugisha to take the floor. Our next speaker is also distinguished. We've had a lot of officials who are within the government that are leading the innovation space. But our next speaker has had illustrious experience at the Big Four and is now a consultant in cybersecurity at Summit Consulting. Mr. Mustafa Barnabas Mugisa is a certified public accountant, CPA, a certified fraud examiner, governance practitioner, and founder of Summit Consulting, and the Institute of Forensics and ICT Security, publishers of iShield 360 and the Annual State of Cybersecurity Report. So we are really in safe hands with cybersecurity here. We really have the thought leaders and practitioners. He works where data, money, and reputation intersect, helping boards, CEOs, and regulators strengthen governance, manage risk, and build systems that are secure by design. He's an alumnus of Ernst & Young, that we proverbially refer to as EY, and has consulted widely on high-stakes strategy risk and cybersecurity governance. He provides tools and proven methodologies to remarkable results through making people appreciate change. Please join with me as we welcome Mustafa to the panel this afternoon. Thank you. We're also joined virtually by SSP Jimmy Haguma, who is the acting commissioner for ECM in the Uganda Police. Mr. Haguma Jimmy is by rank a senior superintendent of police and law enforcement and has served as the head of electronic countermeasures department under the Directorate of ICT in police. He's responsible for providing cybersecurity, resilience, and assurance services, and has built a capacity of over 18 years of experience in the areas of policing, particularly as a technology practitioner of cyber resilience. He's a member of the Council and is a certified ethical hacker, certified hacker for forensics investigation, and the Association of Certified Fraud Examiners. He holds a Master of Science in Information Systems from the Makerere University, a postgraduate studies in social justice from Makerere University, and an undergraduate degree in information technology from Chambogo University. Please join with me online as we welcome SSP Jimmy Haguma. I hope that he can be put onto the platform. Otherwise, these are your panelists, and please warmly welcome them to the panel before we start this conversation. All right, thank you very much to our panelists. Thank you for accepting to be here today. I'm very excited. Like I said, I woke up in the morning pretty early and I got here at 6:45. My hands were itching to ask some questions, especially some of our regulators have issued decisions recently, and I have some personal opinions that are of relevance to some of my clients who are interested in me asking these questions. Hopefully, I'll not be too hard on all of you. But I think we'll start with our government incorporation of e-systems. I think we have an online filing system for court in the judiciary called ICMIS. Immigration now also has an online portal, and a number of the entities that are registering now, FIA, the Passenger Protection Office, everything is submitted online. So there's been significant work that has been undertaken. And this question perhaps goes to Ms. Julian Reju. NITA has led e-government initiatives that are transforming how professionals access public services. But from your perspective, how is this digital shift changing the way legal practitioners interact with government agencies and court systems?
Thank you, Joel. Good afternoon, and our audience online. Joel, I would want to look at it from simplicity perspective. Most of the time when people start talking about digitization and the big words, people get worried. We are talking about transformation. We're talking about citizen transformation. And for me, our citizens, or the people we're looking at, especially for this audience, we're looking at our litigants. How are litigants being transformed? We're talking about transformation. And you know, this word has become a buzzword. Everybody's talking about transformation. Transformation, in our perspective, we are looking at how is our ordinary person able to use technology to improve their lives? And for me, it is access. Other than access, how easy is it for me to get justice? How quickly can I do what I need to do in that term? So what has digitization, that shift, done in our lives? One, for me, we have improved access. I will not labor much on it. Everybody has talked about access. Now you can go and do your registration on any platform in this country. I happen to be one of those that sat in one of your, I think some years back when ICMIS was starting. And we were talking about ICMIS and everybody was looking at us thinking that these people are not serious. They're joking, this cannot happen. But today, we are now not even talking about whether this can happen or not. People are now talking about what can we do next. So in regards to access, we have improved on access, on government services. I can go anywhere, NIRA, URSB. I cannot emphasize more on ICMIS. I happen to be one of the people who have been part of that revolution in judiciary. We have gone far. The second point I want to raise is on efficiency. I know the legal or the lawyers don't like to hear this, but there has been some improvement in regards to efficiency. If I can give case in point in the way you're filing, leave alone filing, let me even not talk about judiciary. If I can just talk about URSB. I personally am not a lawyer, but I can always submit some resolutions and I get them in 2 minutes back, certified. We have improved on time. We have improved on cost. So for me, efficiency in government has greatly improved because of digitization, and that is the transformation we want to see and we are going to see moving forward. With access to justice, if I can talk about ICMIS, I can file. Even some of us who are not lawyers, now we are able to see where our files are. I know which court, what time, and who is going to handle my case without calling my lawyer. That is the transformation we are looking at. So for us, 2 things that I would want to emphasize is that we have seen a shift in access to services, government services, and 2, we've seen some level of efficiency coming through in the way we have been providing our government services.
Thank you very much, Ms. Gillian. I think that you make a critical point in terms of when we digitize, it's accessible. Now, when I returned from the US, I joined the law firm where I work at H&G Advocates, and ICMIS was fully integrated. So there are cases I've taken over that colleagues handled before, and I can access all the documents. I'm not looking for an old file, asking a records person, can you please search, go in the basement of the office building. So I think what you've done is really, really important. But I want to cue in, the director for the Personal Data Protection Office. Not more than a month ago, there was a decision issued by the Personal Data Protection Office, which is of concern to all of us. I use, when I was coming here, because I stay on the other side of town, I use Google Maps when I'm getting here. I have a private email, although I also use Outlook, and Google is an integral part of my life, although I understand they're not registered locally. But in this recent case of Sekama Frank and Raymond Amompire, who's part of our audience, and two others versus Google LLC, the Data Protection Office of Uganda ruled that the Data Protection and Privacy Act of Uganda applies to a corporation, even if it lacks a physical presence in Uganda. Is this extraterritorial approach similar to the framework that we've seen, for instance, for the GDPR and in other jurisdictions? But I think more importantly, what are the implications of this decision for companies that collect and possibly transfer personal data of Ugandan citizens but are not based within Uganda? It's a tough one, but I think we all want to hear your comments on this.
Thank you, Joel. Good afternoon to you all. The Google decision, definitely what it implies that regardless of where you are, as long as you're collecting and processing personal data of Ugandans, the law applies to you. It re-emphasizes Section 1 on application of the Data Protection and Privacy Act. And as was indicated in the decision for Google, they do not have a local office, but they actually gain value from monetizing Ugandans' personal data. And it's not just about Google, it's about any company that is not situated physically in Uganda. As long as you're using and processing personal data of Ugandans, the law applies to you. Applies to you in the sense that, one, as was determined in that decision, you're required to register and have a point of contact within the country or wherever they may be, but making sure that the law is well complied with. Then secondly, there was an element of cross-border data transfers, which are provided for within the Ugandan law, that if you're to engage in any cross-border data transfers, even if you're not in Uganda, you should comply with the law. So even those that are outside of the country, even the ones that are within, because we have many of them that are actually not complying, it's a wake-up call that actually the law, as has always been enforced, but now even with those outside of the country, if it can be enforced against them, then even within the country, you should be alive to that fact.
Thank you very much for clarifying the scope of the decision. And I think for us as private practitioners, we loved to hear that decision because it means there's big business, for data practitioners in Uganda to assist global corporations in registration, but also, to be local contact persons and advise on the Data Protection and Privacy Act. So I think in terms of extraterritoriality, we welcome, the decision, although I know that there's still an appellate process that may be pursued. And I'd be curious to hear from one of the litigants of that case later, what they are planning to do, but maybe we cannot discuss that here. I'd like to move on to, Ms. Caroline Akello Mugisha, again from NITA. Again, it's important because NITA has led so much of the e-government infrastructure, ICMIS, which has changed. There are some lawyers who are saying, no, we should still file physically, but I think that ship has sailed. Like, we can't even debate about that today. But there are real concerns about, this data that is being stored by government. Is it secure? And my question is really on the UG Hub Systems Integration Platform that allows sharing of data across government departments or systems. How is NITA Uganda conforming to the Data Protection and Privacy Act? Because if anyone can remotely access a system, even though they are within the system, if they are hacked, then the system is compromised. So I'd be curious to hear your take on this, given your years of experience in ICT compliance.
Thank you very much, Joel. A very good afternoon to the audience online and those in this room. I think I'll start off this afternoon by appreciating the Uganda Law Society. When I walked in here, the registration was not done on paper. I think we can applaud them. Because for us, especially in the technology world and especially regulators, it is very key for us to see that we are getting not just entities at a government level, but also individuals and organizations in the private sector begin to embrace technology. I will start off by saying that NITA is the regulator of IT, but also what we do is that we provide services to government. We have laid infrastructure and extended internet to close to 42% of the country. We intend to do this, and we are actually doing this to ensure that even the districts can access. And why am I bringing this from that point of view? Because we want even the people that may not have a smartphone in this day to be able to reach at a service center, for example, and be able to access those services, okay? We want you to go online within your system in the comfort of your bedroom and indeed make that application to NIRA as you renew your national ID. Back to the question that Joel asked. These are the infrastructures that NITA has in place, of which UG Hub is one that provides the services. Now, what does UG Hub do? UG Hub is an integration system where government brings together information. We do not put this information on the system. It is a platform, meaning that it is a place where the information can be accessed by both the public sector and the private sector. Now, in terms of what my neighbor here, Becca, does, the law is in place. As long as you collect and process data, it is the responsibility of that data owner to ensure that they put in place the right measures so that internally as they manage the data, and this is not all data, this is personal data that we are talking about today, that, for example, you have the privacy policies in place, you have enhanced your security systems, okay? And when we talk about security system, it includes your people are really the place where you start, okay? Are they trained? Do they have certifications for those that will be dealing with these things as the IT officers? So that is where we start, Joel, to ensure that from an MDA perspective, which is the ministries, departments, and agencies, they're actually skilled to be able to know what they do as they get online. So for us now, when we provide this platform, on the side of the MDA, they have actually done the protection of personal data on that side. But also, when we now provide the interfaces, we do not provide information for which consent has not been obtained. And so I'll give an example. We have a lot of banks and fintechs that come to the platform for information. So when they come on the platform, they will say, okay, maybe Joel, today you're opening up an account. We want your name, your date of birth. They provide the name, date of birth, and the NIN on the platform. So we only provide them the information in terms of the verification that just confirms what they have already provided. So it will be a yes and a no. So the issue then on the privacy of the information on the platform does not really arise. It arises from where the MDAs and then the users of the platform sit. Thank you.
Thank you very much, Caroline. I think that's it's very reassuring because on questions of data, we often associate them with our autonomy, who can access our information, and we feel concerned if someone has access to all my data and they can use it remotely. So it's reassuring to know that even within the government, there are privacy policy frameworks that are consistent with the DPPA And so I'm very quite pleased to hear that, especially that is being implemented. And maybe to move on to, Mr. Mugesa Mustafa, as a cybersecurity consultant, I'm sure you advise people and corporations on having the best cybersecurity practices to secure their information. But from your perspective, what common weaknesses do you see in organizations' approaches to data security? Because we understand it's a real concern. One of the cases that I've studied was a classic case of where a work colleague goes back home with a work laptop, and they have not logged out of the system of the organization, and someone's able to remotely access the system. And that was used to collect people's identity and then do identity theft on the internet. So I'm really curious to hear your perspectives on the common weaknesses that you have seen with organizations in relation to data security.
Thank you very much, Joel, and good afternoon, ladies and gentlemen in the House. The biggest challenge in organizations is the illusion of security. Many leaders think that technology, tools, and policies can fix what is fundamentally a leadership and cultural problem. 90% of the cases that I'm called to support or investigate begin with human error, negligence of staff, and not a failed IT application or somebody in a hood somewhere. So that's why we say that the only patch to human stupidity is training. But that training has to be hands-on. So you're finding maybe that the way security culture as a cyber hygiene is not given due attention by the leaders. Today you have trained somebody, then they move on, they go with all their resources and accesses in the case you have just given. So basically, human negligence, human error are the main problems that causes breach in simple terms. Thank you.
Thank you very much. Thank you very much. That's quite prompt and clear response. I think we've come to, it's unusual to expect that in discussions in some places, so I appreciate that. But also I think the point that you've made on training of personnel, you can have a robust system, but if you've not trained the personnel in the organization, to not keep open passwords, not to write their password somewhere, not to take these remotely accessible devices outside the premises, they can be real challenges. So I agree with that point. I'm not so sure if we have SSP Jimmy Haguma online. Is he online? Can our IT team confirm that SSP Jimmy is online so I can ask a question? Mr. Haguma, can you hear me? Okay, we'll then proceed. We began this conversation at a very critical point where we had Ms. Reju point out to us the incredible work that NITA has done. Especially, we have ICMIS as a lawyer who does both transactional and litigation. ICMIS, for me, I think is the way to go. But also, my key question now is digitization often disrupts traditional workflows. How is NITA Uganda engaging with professional bodies, such as the Uganda Law Society, to prepare the legal sector for a future where service delivery is primarily digital? There's been this view that, previously lawyers would carry heavy files. I remember when I began working at a large law firm, there's a time we filed a large case and we carried so many documents, and that made it feel extremely special. I'm not so sure if we can feel special when you just hit upload on the ICMIS platform. But can you comment on how this has changed traditional workflows and the kind of initiatives you're engaging with the Uganda Law Society?
I think this particular conference, if I call it that, is one of the ways we've been trying to engage Uganda Law Society. But as NITA, we've been working indirectly through the judiciary to see how to partner with the Uganda Law Society. We have been also, of course, working through the Ministry of Justice, working with the Judicial Service Commission on how do we create a lot of awareness to our legal fraternity in regards to digitization. But I want to point out that through our engagements and partners or partnerships with judiciary, we've been working with the LDC. Most of the people in this room, okay, I see a bit of some young ones probably who graduated maybe a year or 2 years ago. Your curriculum has strictly been looking at the manual records management or case management. And we have engaged them, and we are working on a change in the curriculum to involve or to include ICMIS as one of the course units, so that by the time the lawyers come out, they have an idea and understand that this is where you're going and this is what you're going to do when you immediately get into the market. Through LDC, we're carrying out some trainings to ensure that at least the lot that is coming out is well apprised with what the world is getting up to right now. We obviously, like I've said, more indirectly, we haven't done much with the Uganda Law Society, but these conferences and engagements are one of the ways that we have been trying to promote digitization so that we see how to improve on the way we've been doing our service delivery.
Thank you very much. No, I'm very pleased to hear when you speak about curriculum review. I think that's one of the key issues that's coming up. For instance, when I went to law school, we did not have the Data Protection and Privacy Act. I had to win a Fulbright scholarship, go somewhere in the United States to learn about privacy and technology. And I'm not so sure, but I'm aware, because I'm a part of a law school, we've applied to allow the teaching of data protection, but that can only be considered after 5 years because of the accreditation schedule. And there are real challenges, really, in terms of adjusting such that we can equip people in school and even ongoing professionals. But I do appreciate that you were able to make it to this panel on such short notice. I think that signifies the goodwill of NITA. Before now I move to, again, I think I'll come back to Mustafa. I'd like to remind members of our audience that there is a showcasing, if you just look behind or opposite or wherever I am pointing, there's a huge showcase out there. There are excellent innovations in technology, but we also have NERA that's here. So some of you who need to renew your national IDs, there's a platform for you. We have the Personal Data Protection Office. Some of you own law firms, but you're not registered. You're illegally collecting personal data, okay? And we have the regulator here. When the regulator coughs, there is a decision. So let us try and use that. But there'll also be an awards ceremony to everyone who has attended the event, so everyone can feel special. So I was urged to issue that reminder. So thank you. So Mustafa, I'd like to know a little bit more about how businesses can businesses go beyond compliance to build a culture of cyber resilience and ethical data handling.
Thank you very much, Joel. In my experience, I would say compliance is a speed bump and culture is a seat belt. One slows you down, the other keeps you alive. So many organizations, they put in place policies and procedures and think that is the solution. According to me, organizations can implement effective cyber culture. I don't know that, okay, I'm speaking to the audience, but can implement effective cyber policies by making policies part and parcel of behaviors and habits. Are we having the normal workflows that are cyber ready? For example, before you log onto a computer, are you required to, for example, meet the minimum expectations of cyber hygiene to ensure that you have completed your maybe policy and procedure that is required to have read? Many times you go to respond to a cybercrime incident, somebody will give you excuses of ignorance, that I did not know that this exists. So the only solution to that is automated policy manual compliance. Before you access a resource, then you ensure that you have, for example, accepted that you have read, understood these policies and procedures. And this is why you see for most of the online service providers, you don't access the service unless that has been done. But in many of our local organizations, it comes as an afterthought. You access all the resources and then they are required to sign somewhere a cybersecurity policy and procedures. So in effect, it is a document that is available somewhere and that compliance process is not effective. But also is your rewards for people, including cybersecurity. If you are paying the 13th check, for example, or you are rewarding anybody as a star employee, are you including cybersecurity compliance as a minimum? How many hours have you trained in terms of being cyber resilient? How are you ready in terms of taking boot camps for cyber readiness to ensure that you understand how phishing attacks, phishing attacks, and of course the deep voice and so many other things that have come up with the large learning models. So you find people are meeting at the board level, there is no consciousness on cybersecurity. So making it part of culture means that you change processes and systems and include cybersecurity as part of the workflow. Thank you.
Thank you very much, Mustafa. I agree with that, especially on the point of continuous training. The same way we have continuous legal education, every year. Sometimes when you've installed a system and you have an IT guy, people think that then the systems are secure. Yet everyone needs to be trained. So I agree with the point that you have made. And since we're really speaking about cybersecurity, I'd like to cue in the director for the Personal Data Protection Office. It's always tricky in terms of determining what standard of data security people should have in place. Okay, and I would like you to comment on, from a regulator's perspective, what kind of standard do you look at for collectors and processors? Does it vary across, sectors in terms of the data that you collect? But as you answer that, can you also speak about the importance of the core principles of transparency and accountability, especially for collectors and processors?
Thank you, Joel. The question of security of data comes from the risk that may arise in regard to how you handle that data. Yes, the Data Protection and Privacy Act and its regulations require the office, that's PDPO, to gazette standards that are internationally recognized in regard to ensuring security of the data. That is work in progress, but I need to also highlight, as part of the registration of organizations, they indicate their security measures. Now, these do not apply uniformly, because the risk around a mobile money agent will be vastly different from a fully established organization, say a telco. So what we guide is that you need to first analyze the risk to the data that you're collecting, both internal and external. So once that is done, then you can come up with appropriate controls. The controls, start with some of the principles which are provided for in the law, such as accountability. You develop policies on data protection and privacy, indicating the responsibilities of each player that handles the data, and also having aspects of compliance that in case you misuse the data, then disciplinary measures can actually be taken. The same applies to your third parties that you engage and give this data. So those are part of the measures and controls to ensure that the security is actually upheld. The other is around what Mustafa talked of, training. When organizations register, we require them to submit annual compliance reports. And within those reports, they indicate whether they've conducted training around the policies that they've developed. And we realize that actually most of them don't conduct the training. Someone gets a template of a policy from, those days we would say from Google, but now we say from ChatGPT. It's not customized and someone just uploads it. And if you develop a policy, it is not about you, but it's about who handles your data and guiding them. So that training is also key in data protection and privacy. So the other way we ensure that the principles, especially around transparency, are well aligned, that notices, which are publicly facing, indicate who is collecting the data and how you're securing it. Now, they don't go into the detail of the security measures, but more of the guarantee, because internally, the measures are already controlled. You have the information security policies. So those are some of the ways through which you can balance the principles and what we recognize as the security measures. But the standards, what I can end with, we are encouraging organizations at least to have the 27001 Information Security Series. Good enough, ISO 27701 merges data privacy with information security, amongst others that can be adopted. Thank you.
Thank you very much, Director. And I agree with you in terms of the ISO standards which can be applied. But I also like your point on how, I have some clients, and when they approach me now, they are trying to limit the advice I give. So they say, Joel, we already have a policy. Then they send you a policy that is so generic, you know where it is coming from. And they say, just confirm. I think maybe also that speaks to the fact that, practice is changing. I still think the lawyer is relevant because they have to tailor each to the Ugandan law. And I know one of the defenses that was raised in the recent case of Sekamwa and 3 others versus Google was, we have a global privacy policy. And I think having a global privacy policy is indicative of goodwill. But I think that tailoring those policies to the local laws is fundamental and important. And the next question goes to the Director for Regulation and Legal Services at NITA, Ms. Mugisha. We're discussing cybersecurity, but sometimes the public may have less confidence in certain entities because of the power they wield. The Ministry of Justice mentioned that the government is extremely powerful. They access everyone's information, their birth records. So this question is in terms of, with this rise of digital services that your colleague mentioned, what strategies are in place to ensure that citizens can trust, through transparency and accountability, they can trust the systems in organizations like NITA? But as you weigh in on that, can you comment briefly on, are there any lessons we can learn from other jurisdictions in terms of how national ICT systems are being incorporated in a privacy-respecting manner?
Thank you very much, Joel. I think that's a very, very good question, because as we establish systems as government, we establish those systems for the citizens. The services we put there are for the citizens to be able to access them and use them. For NITA, what we have done is to do quite a bit of awareness. We want to start with the awareness for the citizens, and we will be running, we have been running, and will continue to run cybersecurity awareness campaigns. Why? Because we want the citizen to first and foremost know how to utilize these platforms when they get online. From a government perspective then, we have put in place certain frameworks. We put in place information security frameworks, and these are supposed to guide the ministries, departments, and agencies on how they should provide protections within their systems and also within their entities. What they then do with when they've strengthened their environments, it is very easy for somebody to say, if I went onto the website, we've been talking about registrations that have been taken online, for example, for companies, taxes being paid online, okay? Those who want to renew their passports or apply for them and etc. So within the MDAs, we have started that, we provided to them the framework within which they need to follow for cybersecurity, and we are enhancing that because we also realize that the threat environment is no longer the same, okay? We have the AIs coming on board and so much, and we also have so much, okay, not so much, but the risk of malware is there. So if they have these frameworks, they're able to be guided. But in addition to the frameworks, what should they do? They should budget and actually buy those licenses that can protect the systems. And so that is the other thing that we encourage the MDAs to do. The other that we do is to conduct assessments of the MDAs. We go in there and see, have they established those systems in place? But also, as I mentioned earlier, that registration with the Data Protection Office is not limited only to the private sector. NITA has a certificate, okay, for which we got from the Personal Data Protection Office as well. And we have a data protection officer in place. And so this is to be replicated in all of government as well. Of course, it is, it's the beginning. We are not saying we are there 100%, but it is work that is ongoing, and we will surely get there. Last but not least, to provide the citizens with assurance, we ensure that the systems are available. Availability is very key for a system, okay? I mentioned earlier that we have connected government, and we continue to do that. But when the citizens want to access those services, are they available? If they are available, if I can go on that website and get the service on time, real time, is the capacity sufficient? We don't have, those the cycling on the system, but you're able to actually do it in a short time and move on. That is very, very critical. Is the security embedded in those systems? Those are the things that we look at. And therefore, we also have what we call the Security Operations Center. This monitors any traffic that goes onto the MDA, MDA websites and things like that, that might disrupt their services. And so those are some of the steps that government has taken to ensure that we provide a very, very secure environment for the citizens, for government, and then for the citizens that access the services.
Thank you very much. As a Ugandan, just like to clarify that for the avoidance of doubt. This inspires confidence and trust. The fact that there are assessments, we are also subject to the Data Protection Office. Most times we are, helping with clients, firefighting. Have you filed your annual report with PDPO? It's good to know that the government is also under this regulatory scope. I don't know if any members of our audience have any questions. I'm trying to make sure our panel does not exceed an hour. We've been here for 40 minutes, and I would like to ask the panelists to make closing remarks, but I want to make allowance for one question. I don't know if there's a mic there, if someone can help move the mic. We were supposed to have mic runners. I'm not sure if as moderator I can run the mic around, but there are mics on that table. If any of our colleagues from the Secretariat could help, I think that would be great. So we can take one question from the audience, and then okay, we'll take two questions, because once we open it up, yes, if you could, Simon, the microphones are over there. We'll start with the honorable lady in green. They're on the next table, that table. Thank you very much. We'll take from the lady in green and Professor Muchibi, and then we'll be done. If you have any further questions, we are here to take those questions, especially people who are running ICMIS. We have so many questions for you. Yes.
Thank you, Joel, and thank you to our panelists. My name is Hope Atuhaire from Uganda Development Corporation, and NITA, I'm your client in so many ways, so thank you. My question is to NITA, and my question is on the assumption that NITA is driving AI, adoption of AI in this country. Is that correct? And therefore, within the framework, government framework, we would like to know what steps are being taken to ensure that we adopt AI, the use of AI, and whether there are any policies or regulations being put in place that are AI related, or for the adoption of AI.
Thank you very much. I think that's a very brilliant question. I'll allow two more, one from Professor Muchibi and the gentleman in blue over there, Mr. Ivan Ojakol. So we start with Mr. Muchibi and then Mr. Ojakol. I see Mr. Ogoe Alan, a senior partner at a law firm.
Thank you, Joel, and our panelists. I'm always playing a devil's advocate whenever I see Reju on the panel, because I'm very much interested in technology, and I always want to bring the negative aspects, which sometimes they don't tell us, so that we can have the improvement. One, we have regulators concerning data privacy and protection. I'm not very sure whether you are keen to that law and whether that law is really protecting data. Let's be honest. I'll give two practical incidences. One, so many discussions lawyers are having. You are engaging in a discussion. Tomorrow, a security personnel comes up with a recording and posts it on X, sharing your conversations to the public and warning you that we are having all what you are doing. What kind of data protection is that? Let me bring it to the courtroom. ECMIS, video conferencing. Our laws allow an accused to confine with a lawyer in privacy. Today we are having video conferencing, accused persons appearing virtually from prison. How do they consult their lawyers? The lawyer is in court, an accused is in Luzira, and is proceeding, wants to confide some information to the lawyer in confidence. How does he do that? And we are pushing video conferencing without acknowledging rights of the users, the litigants. Reg has talked about. Our system has no protection to that effect whatsoever. And we are transforming. How do we address these core issues that concern lawyers and litigants? The last incident I will still give in this area. The second one decision, I have very serious reservations about it. It is a very local decision which underscored the international trend about it. I digested that case, but I didn't give my commentary. I'll come up with a commentary at another level. But the critical concern I'm bringing to the data, thank you, Joe, because most of them are in the area of data protection. Today, if ECMIS rolls out virtual courts completely and we start appearing virtually, how secure are these proceedings which the law allows to be in camera? How do we deal with them? Matters concerning juveniles, matters concerning people divorcing, because now the law has even allowed pseudonymity. You can proceed in court using pseudonyms, using so many identifiers such that your details don't come out. How is the digital world preparing for that? Which is already happening in the usual courts. I want you, the regulator, to address us on that. Thank you.
Thank you very much, Mr. Muchibi. It's always great to hear from you, having sat in one of your classes at the Law Development Center. Very critical comments that is made. I think some of it are comments, some of it are questions. Some of it may be addressed. So I'll just allow the panelists after the last question to respond and give their closing remarks. We also encourage that, when you make your comments, obviously to maintain decorum even when you disagree with some of these issues. Yeah.
Joel, am I allowed to ask a second question briefly to Carol after asking Baker? Okay, thank you. My name is Ivan Ojakol. I'm happy to be here. Just to add voice to what Professor Muchibi has said, the Sycamore decision, first of all, thank you very much, Baker, for a great decision. But again, he said a local decision to tap into an international market or international trend. And again, if we went back to section 19 of our act that Mr. Birikuja mentioned earlier, there is a requirement that for any data processor and controller to ensure that the country or the territory they're in has adequate measures. And that's where Professor Muchiri perhaps says a local decision for an international market. It sort of ties into a cross-border element and brings in something called adequacy. And so that basically means that a cross-border player like Google has to ensure wherever it's playing, there are adequate data protection measures. So I wanted to ask Becca, are there any mechanisms in place currently, one from East Africa or African, or from the African perspective as far as adequacy is concerned, or ensuring that all of these countries have proper adequate data protection measures? Especially, I mean, East Africa, for example, South Sudan and Burundi do not even have data protection laws. So how are we going to implement Sekamoa's great decision in a territory like ours where only a few countries have data protection laws? And also now quickly, there is a global trend of competition law when it comes to these things, data protection or what have you. Why does NITA compete with private sector players? For example, NITA is providing infrastructure, NITA has data centers, you're out competing all of us, and that ties into competition. A dominant player, a regulator, also playing and competing with the private sector. So how is that going to be handled going forward? Because it raises major competition law concerns as far as I'm concerned. Thank you.
Thank you very much, Mr. Ojakol. I think those are the questions we'll take. Very important questions. I don't know, OJ was in my class at law school. He was our president for the Law Society. I'm just not so sure if who you're asking that question, if you represent ICT companies that want to build the infrastructure. So I don't know how innocuous your question is, or if at all it is, but I'd like to let our panelists, a lot of questions went to NITA and the director, so I'd like to allow Mr. Birikuja to address us, after which we'll have the two NITA officials comment, and then we'll have parting remarks from Mustafa, and then we'll close this panel. Thank you very much.
Thank you, Joel. The question of, is there any protection as accorded in the law, based on the scenarios that you've given? Now, the law, good enough you're in a room full of lawyers, gives you the rights and their obligations. Where you see that a particular person or entity is not adhering to those obligations which are imposed on by the law, there is a mechanism where complaints can actually be raised. And the other one was about the question of adequacy, again, the Google decision. In an environment, starting with Africa, where few countries, especially in the region, the examples you gave, do not have data protection laws, and yet data needs to be transferred. One, Uganda, we are part of discussions to ensure that there is that harmonized environment of data protection. And actually in the East African community, of the 8 partner states, at least 7 have data protection legal frameworks. But South Sudan, the example you gave, is one of them that do not have. So there is work which is already ongoing to develop a data protection and privacy regional legal framework, probably a law or something in that regard. So the approach that is being taken, that it will be an act whereby it will apply across board, whereby if you're looking at adequacy within the East African community, the 8 partner states, there will be that environment. At the continental level, the 2 things have happened before. In 2013, there is the Malabo Convention, that's the Cybersecurity and Personal Data Protection Convention. Few countries have adopted it, but the pace is increasing in its adoption and ratification. But also the African Union Data Policy Framework is looking towards making sure that that environment is created. And within the African Continental Free Trade Area Agreement, Annex 4 on digital trade looks at creating that environment within Africa where there is a harmonized environment to do with cross-border data flows. And this is an agreement that has had the highest adoption in all agreements that, or conventions developed on the African continent. So some work is being done to ensure that cross-border data flows and digital trade will actually be supported, and data protection and privacy will not be a hindrance in any way. Thank you.
Thank you very much. Perhaps if we could hear from Ms. Reju, there were some fairly strong comments. I'm not sure how to term them. I'm curious to hear what you have to say in response.
Yeah, it's always.
But also, especially on the AI issue, there was a key
yes,
comment.
it's always interesting in such rooms. NITA becomes the focus. AI, of course, as part of the emerging technologies, is one of those that we as NITA, we are also spearheading. As government, we don't have a policy yet. We recently set up a committee involved or comprising of a number of stakeholders to start that process. We've already started in developing a policy and a framework with regulations on how AI is going to operate in this country. The unfortunate part is that technology normally moves faster than the laws. Yeah. However, we have already started in Africa. The entire Africa, there are about 8 countries. They already have policies. Rwanda recently, Kenya issued out their strategy on AI. They are also moving as fast as they can. We have, of course, the Africa AI, forum as well. So there's some movement. But as far as Uganda is concerned, we're just starting. But hopefully before financial year, in the government financial year ends in June, we will have a policy and a strategy in regards to AI. So we are getting there. We are getting there. My friend, Mr. Mutivi, first of all, we always appreciate you because you're a champion on ICMIS. We always follow those forums that we are not in, and we see you defending ICMIS to the core. We always appreciate, and of course, you always give us that those pointers to improve and do better. In regards to, I will talk about a bit of the video conferencing in regards to data protection. I have the boss here. He can talk about the data protection as far as video conferencing is concerned. You see, technology is an enabler. It just supports the existing processes and procedures. So by providing video conferencing, we're just enabling a channel on how you can execute what you're supposed to execute. So when you ask how some of the lawyers are not able to interact with their litigants, legally, I have my legal people here, they can speak into that. But from the technology perspective, we're trying to see how we can bring services a bit closer to people. Some people may not like it, others actually appreciate it. When we started discussing about video conferencing, people were looking at it different ways, especially the lawyers. But as far as government is concerned, imagine bringing one of the politicians through Kampala streets, the disruption and the cost that it takes government to bring just one person to court. So for us, technology is improving services. I know from another perspective, they might look at it differently, but my legal colleagues probably can bring in how the data protection comes in from that angle. I want to talk about the recent civil proceedings that were issued out, gazetted, the e-filing that support technology. They support ICMIS into doing what you do best. So in there, I think they're talking about how technology, regardless of whether it's infringing on certain rights, it provides those procedures. So for me, from the tech world, I may not talk so much. All I'm saying is that technology gives us an enabling environment to be able to provide services well and secure. I want to comment about the competition that one of the members mentioned. Why is NITA competing with the private world? We're going to look at it in different ways. We're not competing. Unfortunately, our act as NITA, we are both a regulator and an implementer, and that is how the act was done. That one is a question not for me, but yes, we do both regulation and implementation. But we focus more on public services, which the private sector have a profit element to it. Recently, when we were trying to extend the fiber to the tourist sites, some people commented, "Are you taking internet to the elephants?" The private sector will not go in some of those communities, on some of those areas, because for them there is no business there. There are very few people who would be tapping into that, or the infrastructure. But as government, we are going to roll out. So we are not competing, but in a way we are complementing. Where you are not going to be, we will be as government. And of course, for us, we're focusing on government. We're providing infrastructure to improve on our service delivery. So we are not literally competing. In fact, the private sector is using NITA's infrastructure to make money out of it. So in a way, we're complementing each other. Probably I'll allow Caroline to jump in some of the areas that I may not have answered well, especially around the secure, something around the secure devices. It's again on data protection. Yeah, the recordings that our security people have. I don't know if you have something you can comment in that regard. Thank you.
Yes, if Ms. Mugisha could, if you have any comments on that, that would be great. Also, maybe would advise Ivan, you could lodge a complaint, but again, the complaint would be lodged with the Minister for Trade, who's part of the government. And that's one of the key points we've been making, that, we have a regulator who is regulating the competition sector, and some issues people may be, for instance, the concern Ivan has mentioned. He feels government is doing business which would have gone to private players. So it's interesting. But thank you for those comments, Ms. Reju. Ms. Mugisha, I don't know if you have any comments on the security of systems or privacy that you'd like to add to your colleagues' commentary. Do you have any comments? Okay, thank you. So we'll take some comments. I don't know if now SSP Jimmy. Okay.
I'm sorry to hijack you, Joel, but unfortunately, Professor addressed the question to government. But Professor needs also to appreciate that the private sector in many health economies are always ahead of government when it comes to innovation. And so it is very important that the private sector at least maybe may make some commentary on some of these things. For example, virtual courts. I think this is to do with secure infrastructure. One of the biggest challenges that has been happening in the world has been quantum computing. But we are seeing with large learning models, this problem is getting solved. So we are seeing a lot of computing power. So with computing power, the shift of focus is coming to, in the past, there has been, encryption has been effective mechanism for security because it can keep data at rest, the one which is stored. Now the problem has been, what about data in a transmission? When you're having a court session, there is a live interface. That data, most of the time, it is in clear text. So now, has government in the architecture created mechanisms for securing the tunnel for which that live session is taking place? For example, this broadcast, maybe we are using Zoom. So Zoom is going to give you an assurance that our infrastructure is going to ensure end-to-end encryption from origination up to the person receiving it, decrypted at the end. The biggest challenge as a practitioner I have found in Uganda is many of our solutions that have been developed have made security as an afterthought. It is like you build a house for your own home to live in, and then they tell you, we are going to put a strong room, a bank. So you have to convert that house into a strong room and make it secure. So you find that it is a very difficult calling because it was not made to be for securing variables. And that's what has happened. So until somebody realizes that the system we are using...
where the problems are. I'm going to be in that meeting. Whenever you have a meeting, you accept your FOCA. When is it?
Yeah, so It is until now, I think NITA has a lot of work to do to make sure that the innovators are supported to have security professionals at the time of developing the applications. Most of the time it is a structural problem. The applications were developed with functionality but not security, because that's what the users need. And that's why you have a lot of vulnerabilities. But again, when it comes to, even before we are worried about the digital, even in the current manual system, we are saying that the only secure meeting is face-to-face. I want to talk to Joel, the secretary. I meet him in the middle of the playing field. We turn back to back, and we can talk, share a secret. That is the best security. Anything else is very unsafe. Now, as long as government wants to be privy of a given conversation, even in the traditional court system, it is going maybe to know, because it is privy to so many other things. So the question is, whom are we protecting the information from? And so we can build our architecture with that peace of mind, knowing that somebody who is traditionally interested in our conversation, maybe they are going to access it. So, and that goes to architecturing of the security. I like to believe that whereas some people might die in their sleep, we take precautions to ensure that people will always sleep, but you have a minimum hygiene at a personal level to ensure that when you sleep, you should wake up. And I think that's how I look at technology and security and all these innovations. So how do you ensure that if you as counsel of the client, you have a secret, you must make sure that you use your legal means to meet your client in a way that is safe, one-on-one. And then for the rest, maybe it may be very difficult. Thank you very much.
Thank you very much for addressing those concerns. I think that they go directly towards embedding security within systems, and I think you are best placed to address that. And I'm not so sure if now SSP Jimmy Haguma, if you can hear me, it would be great if you could say hello so I can. Okay, thank you very much. I see you. Very pleased to see you again.
I can hear you. Thank you so much. I'm happy to be with you. Sorry for coming.
Yeah, thank you very much. So I read out your illustrious profile, and the Uganda police has a very, very, very unique and important mandate. And now as we move into a digital space, there's cybercrime. One of the questions that I really was excited to have you address, and I'm looking forward to your answer, is with the increase of cybercrime in Uganda, such as deepfakes, there was recently a video running around where an AI model was saying certain things in the voice of a person, and those words were being used to castigate that person who was campaigning. So people are doing deepfakes, they are hacking, there's a lot of identity theft that's carried across borders. Someone's committing crimes in Panama, but they are affecting a Ugandan citizen. How is the Uganda police planning to handle investigation of privacy and other cyber offenses that are of an international cross-border nature and are affecting Ugandans? I believe SSP Jimmy, I've listened to you before. We would like to hear the position of the Uganda police.
Okay, thank you so much. With all due respect to all the protocol that is in the room, I hope you can hear me, the different government representatives at your different forum. I'm happy to be joining you this call. I'll start by raising that actually the Uganda police is not planning, but is already doing very many things, some of which I can be able to inform you, and others will be on need-to-know basis. We'll start by underscoring the fact that cybercrime is not only a task that is now localized. It's actually a task that is beyond just only the space of Uganda, but because of technology, it has now gone beyond the borders. One of the things that I would critically talk about is the strategic partnerships that the Uganda police has undertaken. One of them, I just attended a brief meeting with the SOC, that is the Serious Organized Crime, with Interpol. And specifically, one of the things we've noted that whereas even as a country, as we grapple on the challenges of collection of evidence and how it is quite laborious, we've come to a point that one of the things is that we cannot deal with cybercrime the way we were dealing with traditional crime. We cannot deal with cybercrime using some of the mechanisms that are already in place. So one of the things is that as a country, we are leveraging on the law that is already in place, but the law in itself has not been sufficient. The other thing has been providing training, and this has been deliberate and intentional training to police personnel, but also to support entities. The other one, which is critical, is understanding that awareness is very pivotal. And I'm glad that Uganda Law Society has found space for us, and we'll be glad to continue finding spaces where we can be able to raise the voice and say that you are as safe as the weakest link, meaning that anything that can expose you will lead you yourself to, first of all, becoming vulnerable. We have seen technology becoming an enabler to crime, and therefore, as we harness different forms of technology, not only in business, even in security, we have gone ahead to now say that it's very important to do risk assessment, risk analysis. The other critical one that I say that there has been a lot of partnership and related trainings that are now being done under the justice, law, and order sector. These have harnessed to enable, because you could do a good job in collection of the evidence, but where you are taking it, the public believes that once a case has been brought to the police, they want to see justice at the end tail. But at times they forget that actually the justice system has very many players that are involved. Now, when we talk about technology, we are bringing in even the custodians, the data custodians, we are bringing in the controllers, certificates authority, not to go into the technicalities. But if you're talking of a website that was hacked, you may want to understand how secure was this website, who was the certificate authority giver. And then when we talk of data that was compromised, where could it have been stolen from, and who was the custodian, and probably who was the aggregator. So with all these coming up in place, it's very important and pivotal that we realize that we need to now go beyond just the borders of the traditional crime. One of the things that I'm looking at in some of the assignments that I'm doing now is to see how we can leverage platforms that have already been able to embrace what we call technology-enabled mechanisms to support our form of investigation, but also support the way we are dealing with cases day by day. I would like to end it here, not to take long, but I'll be glad to hear more from if there is any follow-up question to this. Thank you so much, esteemed panelists and members who are on the call. Thank you. I'm glad to be with you.
Thank you very much, SSP Jimmy Haguma. I think you've preempted the other question I had on how police is adapting investigative techniques to tackle cybercrime while safeguarding privacy. But as we wind up this panel, this is just one follow-up question to you, SSP Jimmy Haguma. What partnerships and collaborations are proving most effective in combating cyber threats at both local and at the cross-border level? If you could comment on that and give your parting remarks on the state of cybercrime, I think that would be a great thing. SSP Haguma.
Thank you, brother. You just have to call me Jimmy. You don't have to struggle with SSP. Yes, I think one of the things that I have seen, there's something we come up with a program we're doing under the community policing, which is awareness driving. And looking at the vulnerability, not just being the business sector, but even in the education system, we've working with other units, we've been able to develop mechanisms of extending our message, not only to the business spaces, but in schools, understanding that we needed to do a cyber education. And this has been one of the methods. The other strategic partnership is even at Interpol, even at other elements like AFRIPOL, they have flagged what we call cyber-related crime, where we talk of cyber violence, offensive and related threats, and compromise to government infrastructure. Now, this has created mechanisms under committees where I've been at the Ministry of ICT and others, looking at the threat in the East African region itself and developing what we call working groups to understand the impact of this. The other that is open in this room is some of the things that you are doing right now. Having such meaningful conversations or discussions help us not to understand that it's no longer working in silos. If we are going to deal with cybercrime, silos will not help us. We have to open the space, but then understand what we are going to share. Like in technology, when we talk about the the access programming interfaces. What do you bring on the table? So what can we leverage from the telecom companies? What can we leverage from the banks? With such mechanisms in place, I believe that we have been able to close many gaps, but also answer other related concerns that have been challenging. My parting shot would be that I want to thank you so much for these conversations and meaning. I would be glad to see that we move out of this room understanding that actually the cyber threat that we are talking of is not far. It's just right at our fingertips with a click of your finger. And therefore, any informed consumer is one who is better informed. If we can raise their awareness, if we can ride on the platforms that are there, the media that is there, if we can think of maybe we issue an article in the papers once in a while, or during the news, I normally see we have sports, we have this. Maybe this is something I would propose that we'll have just cyber news or something to indicate the threats. I believe the more we create awareness, an informed consumer is an empowered consumer. And even the police themselves, they are not aliens to this. They could also be compromised by this. I wish I had more time, but what I could talk about the privacy element is that it's very important that we continue to see how the data privacy regimes are moving and revolving so that we clearly understand that everything that is on the space is vulnerable. And therefore, if we have this vulnerability, we should understand what should we be able to expose. And if it's exposed, whom should we be able to quickly run to? And I believe the police is also joining you in the cyber force defense so that together we can protect our critical assets and improve development as a country. Thank you so much for listening to me.
Thank you very much. Since I was allowed to call you Jimmy, thank you very much, Jimmy. So as we wind up the last parting words from our panelists, we'll start with Ms. Mugisha, then we'll move to the director for the PDPO, and then the acting director for NITA, Ms. Reju, and then Mustafa, and we'll be done. Thank you.
Thank you very much, Joel. Thank you also for allowing me to go first, because I just wanted to add something to what Jimmy has just submitted on for the audience to know what government is also doing. So at NITA, we have what we call the Computer Emergency Response Team. It's part of the Security Operations Center. So any incidences that are identified or reported to that center is investigated quickly, and we work from time to time with police as well to ensure that these incidences are investigated until the solution is found in terms of the resolution of the same. In terms of parting shots, I would like to thank Uganda Law Society once again. I think this has been an excellent event, and I appreciate everybody that has raised a question or made comments, whether online or in person here. I would like to appeal, because as lawyers we are advisors, appeal to you to advise your clients in terms of the services that government offers. We need to get them online. I mentioned earlier that not everybody has got a smartphone, but there are centers that have been created where we can actually move and get these services. So please do provide this support to your clients and even your friends and family. Joel told you that I had certification at NITA. I cannot go without saying, please, yes, you are counsel for those companies, IT companies, your counsel for those fintechs. Please do send them to us to be certified. For the fintechs, in turn, they do get a certification from the central bank. We will support them. We actually do conduct capacity building for them as well. Thank you very much.
Thank you very much. Perhaps if you could hear from Mr. Biri Kuja.
I'd like to thank Uganda Law Society for focusing on technology this year, for it to implore that this should be sustained. In regard to data protection and privacy, whenever I get an opportunity to speak to lawyers, is again to implore you to advise your clients. As the regulator, we are seeing something concerning. Very few Ugandan lawyers are involved in this sector. So we have very many companies that are advised by quote-unquote lawyers. These are people who are not lawyers at all, but because they see data protection is, their clients are asking about it, and the lawyers are nowhere to be seen, they're taking up the space. And yet we have over 5,000 lawyers. The other concerning matter, of course, is, again, the lawyers themselves are not complying with this law. So that explains why we have non-lawyers occupying the space. Law firms are not registered. As PDPO, we receive over, about 4 years we've been in operation, we provided over 300 requests to regulatory guidance. So yes, we are happy to do that, but as the lawyers, if they can take it up, so many people are looking for guidance in this area. So please take it up, both as individuals, but also advising your clients and bridging this gap. Thank you.
Thank you very much. And I think it's really business. There are a few people who are engaged, so I think it's a clarion call to us to focus on the sector. May we please hear from Ms. Reju for her parting words.
Mine really is on e-government. The government is moving electronic, the government is moving digital, and everything is going to go online. In fact, we have a directive that every government service needs to go online. What does that mean? That you need to also start thinking in that area if you have not. It means that you might have to start investing if you have not. We've gotten a few complaints from court that most of our farms come to the kiosks that are there to actually do the filing and do everything there. We are just trying to say that the world is moving that side, government is moving we also need you to embrace technology. Lastly, skilling, digital skilling. You also need to embrace, you need to invest in digital skilling, not only for yourselves, but for your staff and everybody. If you're going to utilize this technology, if you're going to get the services that government is going to provide you, you need to be skilled. AI is here, the other emerging technologies are here. You need to learn how to use them and utilize them. So for us as government, we're going to do our best, but we also need to work with you to ensure that you also move with us. Thank you.
Thank you very much, Ms. Reju. May we please hear from Mr. Mugisa.
Thank you very much. Technology has come for us. It will make you poor or rich. Depends on how you adapt it. So you have to embrace it. I wanted to look at it, especially like AI, as that junior associate whom you give every document, they photocopy for you. Some of them could photocopy as they keep their own copy. So you have to implement what we call zero trust architecture. You trust after controls. You don't open your house 100% by asking need to use. Thank you very much.
Thank you very much, Mr. Mugisa. Again, thank you to our panelists. I've had the incredible, easy task of moderating. You had to face the hard questions, some of which came from me, some from the audience. And so I have to recognize, thank you very much, Mr. Birikuja, Ms. Reju, Ms. Mugisha, SSP Haguma, and Mr. Mugisa, thank you very much. My last words as a panelist. Over the last 7 months, I've been serving on the International Bar Association Task Force for Artificial Intelligence. And one of the things we've been doing has been thinking about how AI has been used by law firms, by the judiciary, and we've been coming up with working guidelines for how AI must be incorporated in the legal profession. And what has become clear is that there is real opportunity in adopting AI. But even as we adopt it, as a profession, we must think of our duties. One of our most important duties is the duty of confidentiality. And that's the point that Professor Paul Muchibi was making, which in one way overlaps with data security and privacy. I'm very pleased that our panelists have done an incredible job by explaining how this duty of confidentiality transforms into privacy that creates a standard of data security. And as lawyers, I'm excited that the most perpendicular president and the vice president have organized the Tech Fest. When I saw this, I was so amazed. Then I got appointed on the committee and I was like, I have to serve 110%. So it's an extreme honor and one of my deepest pleasures to be able to serve on this committee. So I'd like to thank the president and the council for this appointment. And I look forward to interacting with all of you for the next one day. Thank you very much. And I hand over back to the MC. May God bless you and for God and my country.
Thank you. Thank you very much.
Perhaps a group photo before we go down.
Yes, first a real round of applause. Let us not take this for granted. There is no better time to be a lawyer than now. At some time we were seated with Professor Sempevo and he was giving us the stories of 1972 and you didn't want to be in that time. The best person they had around them was a typewriter and that was the only person who could be relied on. The beauty with what we have had today and the wisdom we have received is I am now comfortable to practice because I know I have people who can back me up. Thank you so much for the panel. Thank you so much. You know, words might not say everything. It comes from our heart. The Radical New Bar, the Uganda Law Society is so grateful. Thank you. Mr. Basoga, what you did was so easy. The harder thing is to thank the team. You know, these are heavenly sent individuals. Your relevance has only begun, you know? So we are so grateful. We want to take the opportunity to appreciate, and also because it has come to the close of the function, we have been moving around and distributing presents, and the panel is not going to be any exceptional. We are going to take the honor to present 1 or 2 items of appreciation to them, and we're going to be led by Sheila, who is going to help us to do this, and then we shall want to wind the day with a few remarks, closing for that matter, as we guide us to move down to the tent, because the festival is also extended down at the exhibition. We know you're out of time, but on your way out, you're going to come across a tent that you can take a very short time to pass by and appreciate more information. Thank you so much. We're going to have a group picture after the presents have been distributed. Thank you.
Thank you. My name is Namahe Sheila. I would like to extend a very heartfelt appreciation to the panelists. Thank you so much. Your discussion has been very, very insightful. Councillor Joel Basoga, thank you so much. Thank you for the good moderation. From the Radical New Bar, would like to give you a small token of gratitude. We hope you take it in good faith. It's both our privilege and honor. Miss Julian Reju. Oh, you can't hear me, sorry. Miss Julian Reju, please receive this token of appreciation. Mr. Baker Birikuja. Miss Caroline Mugisha. Hope that's the right name. Mr. Mustafa Barnabas Mugisa. Thank you so much. Last but not least, our very brilliant moderator, Councillor Joel Basoga.
Thank you very much.
A group picture, please.
You want us to stand?
Yes, right behind the. I call the VP.
Yeah.
Okay. Maybe it needs to be in a picture. Our most perpendicular Vice President, please, would like to invite you to. Council members. Should I? No, like in the picture first. Yes.
As you can see, the people walking up front are the reason behind the success of this story. So these are council members joining the most perpendicular panel. We're not going to choose which one was the most vibrant panel because none of them was ending. That was so brilliant. We had a very good session, and we want to thank God and thank every individual that has given time to this function. We are so grateful. We are so honored. Yes, there was women in tech on the other side, and we had a very, very nice time. SSP Jimmy Haguma, we appreciate. We are going to give you a token of appreciation digitally. Because you know we are transformed. So SSP, wherever you are, we thank you. We had a little bit of a glitch, but we are also going to suggest that you join us tomorrow in one of the sessions. We are so grateful. Thank you so much. Thank you, Sheila, for joining us. And ladies and gentlemen, we're going to have to hear from the Vice President of the Ugandan Law Society, who is going to give us closing remarks, and he will request us, like we have said before, to join each other in the tent to see if we can benefit from what is down there. And also be reminded that NERA, that is in the house and has been a part of us, is available over there. There's some kit for renewal of IDs for those that did not or haven't yet renewed. Thank you so much, ladies and gentlemen, the Vice President of the Ugandan Law Society. Thank you.